Good morning, everyone. Today is June 6, 2019. Celebrating the, I guess it's, was it the 44th? No, I lost track of time. 45th anniversary of the D-Day invasion. So
75th.
75th, where am I?
I was going to say, that's, wait a minute.
Well, it must have occurred in the 80s, I don't know when it was. But anyway, so...
That's the early 90s.
And of course, our thoughts and prayers go out to the families of those who lost. I know my dad served in the Second War for 2.5 years, but anyway. So that's what today is, and moving on from there, I am calling this meeting to order. I'm going to ask Mr. Wickman to lead us. Rand, please, in the pledge.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. My opening remarks are limited, as usual. I'm polling for conflict of interest. Do we have any?
So financially, no, but this development actually borders my southern property line.
Okay.
So it's literally connected to my property. And I don't feel like I'll have a problem being fair and impartial.
Okay. Pat, that's okay with you?
Yes,
Okay, fair enough.
that's perfect.
All right, then. So attending, we do have Commissioners Duncan, Brooks, and Filios. Do we have any changes to the agenda? I don't hear many. So we're going to move right on with deliberations. And this is item 5A on our agenda, MSP 18-0003, McCarthy Estates. And Vlad, I'll turn it over to you.
Good morning, Commissioners. For the record, Vlad Finkel with Kootenai County Community Development. This is a request by McCarthy Capital Inc. for the approval of a major subdivision in the rural zone. The subject property is located just west of the intersection of Garwood Road and Highway 95. As you can see, based on the Google 3D overlay, the subject parcel is fairly wooded, and it's fairly level with some improvements on the property. I believe that either the current owner or the previous owner had constructed some FPA roads for logging purposes in the past. As stated, this is zone, the property is 136.7 acres in size, zone rural. The comp plan designation is suburban. The application consists of a 26-lot subdivision. Each of the lots will be 5 acres or greater in size. The access to the subject property will consist of 2 access points, one from Dolan Road to the west and one from Garwood Road to the south. As you can see, the portion of the property on the south end, which will have an impact on one of the lots, will likely be acquired by Idaho Transportation Department for a future construction of Garwood overpass over Highway 95. At this time, we have received a letter from ITD that they are in the works of approving a budget and doing some final design of the overpass. However, they have not been in contact with the applicant at this time to acquire a portion of their property. It appears that they may at some point acquire up to 2 acres of lot 15, which is directly to the east of the access to the subdivision off of Garwood Road. One of the things that we brought up to the applicant was, do they know if it will have any impact on the access? And as far as I know, the applicant intends to, based on the phase-in plan, they intend to construct phase 1, which would be the northern portion of the parent parcel, and wait until the necessary improvements for the overpass are complete so that they could make the much needed adjustments to the Garwood access to the subdivision. Based on state law, and we could verify with our legal counsel, is through the right-of-way acquisition or through the exercise of eminent domain, no municipality can hold or be punitive to the underlying property owner. Therefore, we would deem this parcel of land or the subject lot, once it's platted, as conforming and eligible for any outright permitted uses, conditional uses, or special notice uses at such time that it occurs. So it would have no impact. These are some of the photos of the property in question. As I stated, that the applicants have in the past constructed some logging roads. I believe some of them will in turn be improved to highway district standards to serve the subdivision. I forgot to mention that the applicant is proposing to have this subdivision be gated, and all the internal roads will be maintained and improved as necessary by the homeowners association. The highway district did comment on this matter and provided some comments that the applicant will have to address prior to final plat recordation. We did solicit comments from the following list of agencies: Water, Department of Environmental Quality, Bar Circle S Water Company, and Panhandle Health District will be reviewing the connection of the proposed plat to the existing Bar Circle S Water Company in the area. Said company has provided a will serve letter stating that they have the capacity to serve this subdivision. We have received a favorable recommendation from Idaho Department of Water Resources stating that they have appropriate water right to expand their service area. We did receive a comment, as I stated, from Idaho Transportation Department with their intent to make the necessary improvements to the overpass, or construct the overpass and make the necessary improvements to Garwood Road itself. One of the more interesting comments that I have received, and I don't believe I've seen that in the past, was from Lakeland School District. And it's interesting that they, the superintendent states that they're not opposed to this development and they're not opposed to the, the growth in the area, but they are concerned that the existing school district is, I don't know if that's the right word, but is suffering from the influx of kids in their area, and Garwood Elementary is one of those. They have had to bus kids off to different schools just to provide the services, and one of the recommendations that they made is they're asking for the developer to either dedicate land for future school district improvements or infrastructure improvements, or to pay cash in lieu of. Unfortunately, we don't have any mechanism at this time, unless Mr. Braden can assist on this, but to implement that as a condition of approval for future assistance to the school district. But I just want to bring it to your attention that this is becoming...
Mr. Chairman?
Yeah, please.
May I interject? David Callahan, Community Development Director. Hillary Anderson, my counterpart with the City of Coeur d'Alene, has, as you know, but the other commissioners might not know, has requested a joint meeting of all the school districts. I plan to attend, and the chair plans to attend, to discuss this very topic. And so we will at some point work through the issue, at some point at least have it back in front of you as a concept of what to do with this in the future. But at the moment, the short version is we really have no way to deal with crowding in the schools.
Thank you.
During the initial public comment period before the hearing examiner, we received a total of 9 comments, 5 in support, 3 neutral, and 1 opposed. As requested by Commissioner Duncan, we have included the list of criteria for approval of a major subdivision. Based on review of those items, I have concluded, and so has the hearing examiner, that the request meets the intent of the criteria for approval of a major subdivision, and therefore staff had recommended approval. A public hearing before the hearing examiner was held on May 16th, and subsequently on May 27th, the hearing examiner submitted a recommendation approving their request. I stand for any questions that you have at this time.
Questions for Len?
I don't have any.
Are we approving the entire or phase one at this time?
You are approving a preliminary plat consisting of both.
Consisting of both, okay. I don't see any serious concerns. Obviously, the hearing examiner is recommending approval. The lot sizes are consistent with the zoning in the area. I don't really see any reason to object. No further questions? I guess then I would entertain a motion, presumably consistent with the conditions established by the various agencies.
Sure. I move that we approve MSP 18-0003 McCarthy Estates with the conditions outlined by staff and the hearing examiner.
I second the motion.
Bill Brooks.
Aye.
Commissioner Duncan.
Aye.
Chairman Philios.
Aye. Motion carried. MSP 18-0003 is approved. Moving on then to item B. Permit number SDP 19-0065, fee waiver for Kootenai County Solid Waste. It's a request by Lorene Chafin to waive the site disturbance fee in the amount of $285.
Mr. Chairman, this is
Go right
a
ahead.
customary request we get from all of our other agencies within the county whenever we process something for them. I always recommend that you approve it because it makes no sense to take money out of their budget and put it in mine.
Questions?
I'm fine with that, Pat. Anything we should be aware of?
No.
Okay. We're good? Motion.
I move that we approve permit number SDP 19-0065, which is the fee waiver for Kootenai County Solid Waste.
I second the motion.
Bill Brooks.
Aye.
Commissioner Duncan.
Aye.
Chairman Philios.
Aye. Motion carried. So that ends the deliberation segment of our meeting this morning. Moving on to item 6, which is our business segment, but I guess we'll have to
Changing
execute
the
first.
guard. No signings.
No signings today, okay. So item A, the only item under the business segment, consideration of allowing staff to contact the Department of Building and Safety regarding unsafe mechanical work by an unlicensed contractor, potential action item. Director Callahan,
Thank
please.
you, Mr. Chairman. For the board's knowledge, in the past, previous boards have prohibited us from contacting any state agency with any complaints we might have. That's been the past. The issue we have in front of us is one of our inspectors went out and found unsafe conditions by a local contractor. It had to do with, in this case, gas fuel loading, and then the sort of thing that could have killed someone. And so we would merely like to be able to contact the state building division and just mention that this contractor did this work improperly, because we think it's the right thing to do. But if I've missed anything, Chief Building Official John Mills is here.
For the record, John Mills, Chief Building Official. In this particular case, the individual is not licensed contractor. It came to our attention when the owner felt something was not correct, realized that a building permit had not been applied for or issued, and did some research and discovered that this individual was not licensed. Subsequently, we researched the state records, could not find a permit or a license, and in the process contacted one of the state mechanical inspectors, and he made the comment, no, he's not licensed, and he is a member of a group that they've been trying to get more information on and requested that we forward information. Because of the previous prohibition, we're requesting that now, and it's a request that I do not take lightly. It's a request that I would only, if precedence is made, utilize in extreme situations. In this particular case, gas piping line inside a fire pit, to me, is extremely dangerous. To date, I have not received listings of the burner that was used or of the installation instructions, which I requested from the installer. That is the primary reason to be used only in extreme cases, that we don't want to see the situation repeated and somebody does get hurt.
So to me, this looks like almost two separate things. If it is agreed, the homeowner brought it to your attention, yes, this is wrong, wouldn't the homeowner make the complaint to the state?
If they know.
Well, I mean, it
This
sounds
particular
like,
The
case,
homeowner,
Right.
the homeowner was, when she came in to get the permit, she was notified that on that end of it, it becomes her end of it to do the state.
okay,
The reason for the request specifically was because during our research, we were requested to give our photos and that type of stuff to the state, not as a complaint, but to support theirs, and it could be construed as a complaint.
so to me, that's the second part. So the first part is if a homeowner has an issue, they should make the complaint, but you've been specifically asked by the state to provide information. I don't have a problem with that. So to me, that is not you going to the state filing the complaint. They are asking you for information, and I think that in this case, cooperation is appropriate. So that's kind of where I stand.
Bill?
I would agree. I mean, certainly someone who's doing that kind of potentially unsafe and dangerous work has got to be stopped, especially since they're not permitted. But I really don't have any problem with your organization bringing that to our attention or even to the attention of the state when they find it. That's a step further than what Leslie's talking about.
Well, how about if on these sorts of situations, we just come to you and like you
Case by
just did,
case.
tell you
Yeah.
what's what? Because it's fairly rare.
I was
I
gonna
would
say,
appreciate that.
it doesn't happen very often,
Right.
but
Okay.
Do you
John,
have-
anything else?
That's it.
I think, I think when it comes to our, when something like that comes to our knowledge, I think it is very appropriate to, cooperate with the appropriate agency
Agencies.
to, in their investigation, and part of it is just, part of it. It's not totally altruistic, part of it is to, minimize any potential liability we might have, which I don't think we would, but in the case, we could at least say that, yes, we did this.
It's interesting, I guess there was a comment made by our ICRIMP representative more than once. And he said the reason, and maybe there's some levity in this, I guess, is the reason we have counties is that the state does not want to collect taxes or get involved with health and safety. And those are probably our two primary charges, I think, and I think this falls right in there, so yeah. I'm good.
Thank you.
Pat, we don't need a formal motion, do we, here?
No,
Okay.
the consensus direction is sufficient at this point.
So, okay, then, public comment. I stand corrected from what I said earlier. I said 44 years on D-Day. It was
Oh,
actually
seven.
June 7th, 1944. 92% death rate on Omaha Beach. 92%. Over 9 out of every 10 troops that landed were killed. Much less so in the other locations. But in any case, we do honor those, and let's hope it never has to happen again. On that note, 9:20, meeting adjourned. Thank you.